All right, class, settle down. Settle down, please. Take out your notebooks and uncap your pens. Sit up straight. Today, we are dealing with an absolute cornerstone of commercial law, and more importantly, a guaranteed fixture on your Indian Contract Act final examination. We are going to master the exact structure required to secure full marks on the law of pledge and bailment. I expect absolute silence and focus. The structure we cover today is precisely what the Karnataka State Law University evaluator expects to see on your paper. Let us begin.
Here is our exact agenda for today. Number 1, Introduction to Contract of Pledge. Number 2, Pledge versus General Bailment. Number 3, Pawnee, Statutory Rights in Default. Number 4, Key Duties of the Pawnee. And finally, number 5, Pawnor, Rights and Obligations. Copy this exact synopsis down word for word. It goes on the very first page of your answer script to instantly impress the evaluator. Let's move on.
Section 1, Introduction to Contract of Pledge.
A strong, definitive introduction is absolutely non-negotiable when you are tackling a 16-mark question. Write down the text exactly as it appears. A pledge is a special form of bailment under the Indian Contract Act 1872, where goods are delivered as security for a debt or performance of a promise. It is widely used in banking and commercial transactions. Now stop writing for a second and look at me. When the KSLU evaluator is scanning your paper with their red pen, they are hunting for two specific phrases. They are looking for the words special form of bailment, and they are looking for banking and commercial transactions. Give them those exact phrases in your opening paragraph, and you have immediately secured your first 2 marks. Moving to the statutory definition, Section 172, Indian Contract Act 1872. A pledge is the bailment of goods as security for payment of a debt or performance of a promise. Note this down verbatim. Now let's dissect the absolute crux of this definition. The operative phrase here is security for payment. I want you to take your pen and double underline that phrase on your exam sheets right now. See, if goods are given merely for repair or for safe custody, that's just a general bailment. But the very second those goods are kept as collateral, as a shield to ensure a loan is repaid, it transforms into a pledge. That purpose of security is the living heartbeat of Section 172. Every contract requires parties. Write down the statutory parties in a pledge. First, the pawnor, the person who delivers goods, meaning the debtor. Second, the pawnee, the person who receives goods, meaning the creditor. I am strictly instructing you to write these definitions on separate lines to create maximum visual clarity for the grader. Do not bury these vital terms in a messy paragraph. Is that clear?
Section 2, Pledge versus General Bailment. This is a classic, high-frequency short note question. I want you to draw a strict vertical line down the middle of your page right now. We are constructing a 5-point matrix. Point 1, meaning bailment is the delivery of goods for any purpose, versus pledge, which is delivery specifically as security. Point 2, purpose. Bailment is for any purpose, versus pledge, which is strictly for debt or security. Point 3, parties. Bailment involves bailor and bailee, versus pledge, which involves pawnor and pawnee. Point 4, right to sell. In bailment, the right to sell is not available. In a pledge, it is available on default. Finally, point 5, nature. Bailment is general in nature versus pledge, which is a special type of bailment. You must present this exact 5-point matrix on your exam sheet. This tabular format is not a suggestion class. It is the most efficient way to secure maximum marks without wasting time writing long, rambling sentences. Beneath your table, write this exact concluding statement. Conclusion: every pledge is bailment, but every bailment is not pledge. Listen to me very carefully. Finishing your distinction table with this exact legal maxim demonstrates a profound conceptual understanding to your examiner. It proves you understand the genus and the species. Bailment is the broad genus, pledge is the specific species. It's a brilliant way to close the answer. Moving on, Section 3, Pawnee, Statutory Rights and Default.
Wake up, everyone. This is the most mark-heavy section of the entire syllabus. Copy down the rights of the Pawnee, referencing sections 173 to 175 and 163. First, right of retainer under section 173. Can retain goods for payment of debt, interest, and necessary expenses. Second, right to extraordinary expenses under section 175. Can recover from Pawnor. Third, right to receive accretions, where section 163 is applicable. Any increase belongs to Pawnor but is held by Pawnee. Here is your absolute exam strategy. Citing sections 173, 175, and 163 correctly alongside the headings is the only way to elevate an average answer into a top-tier answer script. Without the section numbers, your answer is merely a layman's guess. With the section numbers, it is a formidable legal argument. Now, what happens when the debtor defaults? Right? In case of default, Section 176. There are two options. Write these exactly. Option A, sue and retain goods. The pawnee may file a suit and retain goods as collateral. Option B, sell goods. The pawnee can sell goods after giving reasonable notice and can recover deficiency if sale proceeds are insufficient. I want to emphatically dissect option B for a moment. Look at the phrase reasonable notice. Underline it thrice. The mandatory requirement of reasonable notice before a sale is absolutely critical. If you're solving a practical problem question and you fail to mention whether reasonable notice was given, you will face a heavy penalty from the evaluator. A sale without notice is completely void. Write down this case law. Lallan Prasad v. Rahmat Ali. It held that the pawnee must return goods on payment of debt and rights must be exercised lawfully. Now take your pen and draw a physical, dark box around this case name on your notes right now. This is exactly how you capture the KSLU evaluator's attention for a 16-mark answer. But you cannot just drop the name. You must explain the facts and the ratio discendiendi. Briefly, the facts. The defendant pledged airplanes to the plaintiff for a loan. The defendant defaulted and the plaintiff sued for the debt. However, during the proceedings, it was discovered that the plaintiff had already sold the goods and could not produce them. The final ratio discendiendi of the Supreme Court. The court stated that under Section 176, if the pawnee elects to sue for the personal debt, he absolutely must be in a position to deliver the pledged goods upon payment. The absolute relevance of this case is that it proves the pawnee's right to retain is completely extinguished the very moment the debt is paid. If you have sold the goods unlawfully, you lose the right to sue for the personal debt. Write that down in your boxed format.
Section 4. Key duties of the pawnee.
Write these statutory duties down verbatim. 1. Duty of reasonable care under Section 151. Must take care like a prudent person. 2. Duty not to make unauthorized use under Section 154. 3. Duty to return goods under Section 160 on repayment of debt. 4. Duty to return accretions. You need to list these exactly as bullet points on your exam. For example, if the pawnee receives a cow as a pledge and that cow gives birth to a calf, the calf is an accretion. The pawnee must return both the cow and the calf upon repayment. Do not bury these distinct duties in a messy paragraph. Number them clearly 1 through 4.
Section 5. Pawnor rights and obligations. I demand your full attention for these final rights. Copy this down. Rights of the pawnor. First, right to redeem goods under Section 177. Can redeem goods any time before sale. Second, right to proper care. Pawnor can sue if pawnee is negligent. Third, right to receive surplus. After sale, excess amount must be returned. Let's closely dissect Section 177's any time before sale clause. Listen to me. This is a favorite trick question for KSLU examiners. Even if the stipulated time for repayment has expired, the pawnor's right of redemption is not immediately extinguished. The pawnor retains the right to redeem those goods right up to the very final second before the pawnee actually executes a lawful sale of those goods. Make sure you understand that distinction clearly. Time for your second major case law. Write down Bank of Bihar v. Damodar Prasad. It recognized the rights of parties in guarantee and pledge-like situations, emphasizing creditor rights. Box this case on your answer sheet as well. Let's analyze the background and ratio. A bank advanced a loan secured by a guarantee, and the principal debtor defaulted. When the bank sued, the defense argued that the bank must exhaust all of its remedies against the principal debtor before pursuing the guarantor or the collateral. What was the ratio discedendii of the Supreme Court? Absolutely not. The court held that the creditor has the immediate right to enforce their security or pursue the surety without having to exhaust other remedies first. The absolute relevance of this ratio is crucial for your exams. It firmly anchors the robust, unyielding protections afforded to creditors and banks in commercial pledges under Indian law. The creditor's right to realize their security is simply paramount. Let us close the loop with the duties of the pawnor. Write these strictly. First, duty to repay debt. Must repay loan with interest. Second, duty to bear extraordinary expenses incurred for preserving the goods. Third, duty to indemnify pawnee for loss due to pawnor's defective title or fault. Fourth, duty to disclose defects in the goods pledged. Ensure these 4 points are explicitly numbered 1 through 4 on your exam paper. This perfectly completes the comprehensive legal relationship between the two parties. Finally, copy down this exact concluding paragraph. Conclusion.
Pledge is a specialized bailment for security, providing strong protection to the creditor while safeguarding the debtor's rights. The law balances interests through clearly defined rights and duties. Memorize this. This is your powerful, summarizing sign-off for your 16-mark answer. It shows the evaluator that you understand the macro-jurisprudential balance of the Indian Contract Act. Before I dismiss this class, consider this question. If a Pawnee sells the pledged goods without giving reasonable notice under Section 176, how will you defend the Pawnor in a court of law? I am posing this strict exam-style application question directly to you. Challenge yourself tonight to apply the exact framework, the exact sections, and the Lallan Prasad case law you just copied down to solve this real problem. Master the structure and you will absolutely dominate the KSLU examination. Class dismissed.